In criminal cases like this, each side presents their evidence in court, but the burden of proof lies with the prosecution. This means that the prosecuting attorney must prove the defendant is guilty beyond a reasonable doubt. This is a higher burden of proof than in a civil case, and means that any reasonable person would find the defendant guilty based on the evidence presented by the prosecuting attorney. Throughout the pretrial phase, lawyers may challenge evidence that is presented by the opposing side. This ensures that each party receives a fair trial. Several ways lawyers may challenge evidence include questioning that evidence was obtained according to constitutional mandates, requesting that the trial be delayed, or asking for the trial's venue to be changed. The Sixth Amendment to the Constitution demands that all citizens be granted fair and speedy trials. However, sometimes a defendant does not have access to proper legal assistance. This happens in cases where the defendant cannot afford to hire private legal counsel and is appointed a public defender instead. Public defenders have very high case volumes and therefore are not typically able to follow up on all details of each case. In these cases, the defendants are victims of what is known as assembly line justice. They are quickly ushered through the criminal justice system and, as a result, may be falsely convicted of a crime. Sometimes, a judge will exercise their power of discretion, which grants them the right to consider facts of the case, deliberate, and come to a decision that may or may not be supported by the evidence presented at trial. This provision protects defendants who are represented by inefficient attorneys. If all else fails, the defendant may be able to appeal the verdict. Defenses to prosecution. Once the defendant has been charged with a crime, their defense lawyer will examine the evidence and construct a defense, or a series of arguments that they will present in response to the prosecuting attorney's arguments. Several types of defenses are: not guilty. The defense attorney will argue that the defendant did not commit the crime. They will likely argue that the defendant has an alibi, or an explanation of why they were not at the scene of the crime when it was committed. Guilty. The defense attorney may admit that the defendant committed the crime, but then argue a justification, such as self-defense, insanity, or that the defendant was under the influence of drugs or alcohol when they committed the crime. Post-trial appeals. Once a verdict is given, the convicted offender may have the option of appealing the court's decision. An appeal is a request for a new hearing, asking the higher court to review a verdict to check for any legal errors that might have influenced the decision. Offenders who plead guilty do not have a guaranteed right to an appeal like those who are convicted by a jury or judge. Those given a death penalty are also automatically entitled to an appeal. Some grounds for appeals are legal error, such as improperly presented evidence or lack of sufficient evidence, or misconduct on the part of jurors, attorneys, or judges. Corrections. We remember from Unit 4 that a sentence refers to the punishment an offender must endure after being found guilty of a crime. It can include prison time, community services, financial restitution, and even the death penalty. The corrections system includes jails, prisons, halfway houses, and parole systems. Many offenders are sentenced to jail time, but less serious offenses may result in the offender being enrolled in the parole system. In Unit 4, we also learned that the death penalty is the most severe sentence an offender can be given. Currently, the death penalty is illegal in 19 states and is legal in 31 states, as well as being legal federally. Typically, this federal sentence is reserved for particularly disturbing murder cases. The death penalty is another of the most hotly debated issues of modern times.